which is more serious, my lord, in my personal view, my lord, subject to your lordship's, my lord, accepting that. This is 19th March 2015. Please read, my lord, 1. Then please read 3. 3 is, my lord, very, very serious. It's not just Zindabad. It is again 15th of September.
My affidavit, my lord, which I filed day before yesterday, my lord. I filed another affidavit, my lord, giving more details, my lord, which is completely spreading a venom, my lord. My lord, that is, my lord, he states in his statements, my lord, like while talking to the press, Kashmir.
May I make a request, my lord, as it is we are short of time. Let us finish. Please.
No,
Allow-
there is-
let me finish.
Mr. Judge,
Yes,
Mr.
Lord,
Solicitor,
with a sense of
let's see what the solicitor has to say, and we'll come back to you in a moment because we want to get on with the merits now.
That's
No,
right.
correct,
my lord.
correct. Lord, that's all,
Give us a
Lord,
moment
our
to read.
intention is. Lord,
Yes.
with a sense of responsibility, I received the affidavit yesterday. I went through in the night. I would request your lordships to see 3 statements, and I leave it to your lordship's conscience. Lord, please come to page 6. And I'm saying this with a
I'm
responsibility.
sure Mr. Sibal
As a-
will place the affidavit before us in the morning.
It's not there.
As a citizen of India, my lord, forget,
All right, one
we are all citizens
All
of
right,
India.
just a second. Mr. Sibal, yes, please, let's have a look at the
My lord,
affidavit and-
there's
Lord, can I show, my lord, only
Lord,
3
this is only-
pages, few lines.
Again, it's just, my lord, I'm sorry to say, this is all being televised.
So you file an affidavit.
It's all being televised.
my lord, I'm
Let's-
statement, I'm not doing.
let's-
it.
All right.
You are making
Mr.
these
Judge,
statements
Mr.
in
Judge,
rallies.
Mr. Judge, one second.
Solicitor is there.
Solicitor is in charge on this side. We'll hear.
Allow me, my lord, before Mr. Sibal responds, allow me
Of
to
course,
read.
I'm only telling Mr. Judge that you are in charge on your side, so let
Lord,
one
kindly
person.
see, my lord, page 6.
All right.
I'll not read everything,
And then
page
we'll
6.
immediately come back to Mr. Sibal.
Page 6, my lord.
Don't read it, just let's.
Para
see
2, I'll not read, my lord. Para 2. My lord, the first thing which was yesterday, my lord, highlighted was in the assembly. Para 2. This is in Kupwara in a public rally. My learned friend has an objection of it being televised. He said this in a public rally. Then, please see 4. 18th March 2019. My lord, before the presidential proclamation. Then 5. Lord, 5 may look innocuous, but I'll show, my lord, how it is not. Lord, 5, Lord, whenever terrorist attacks takes place, the terrorist is killed, the civilian is casualty, and the security forces are killed. The sympathy is only for terrorists and the civilians. Please come to page 8 directly. Lord, only as per report in Greater Kashmir and thereafter the later part. Then kindly come to, my lord, page 11, my lords, which is more serious, my lord, in my personal view, my lord, subject to your lordships, my lord, accepting that. This is 19th March 2015. Please read, my lord, 1. Then please read 3. 3 is, my lord, very, very serious. It's not just Zindabad. It is again 15th of September 2019. Then 4.
Yes, we've seen it.
My lord, 4 middle.
We have,
My lord, 4 at the bottom.
we've seen it, we've seen it.
India is referred to as if it's a foreign country.
All right, we've. Yeah, yes, Mr. Sibal.
My lord, therefore, I was
Will you
insisting
please allow
yesterday
me now, sir?
that his affidavit must say that I withdraw these statements. I do not support terrorism. I do not support any separatist activity, and no citizen in this country can logically
We must have a
any
uniform
objection
affidavit for
to
every
file it.
citizen to file this, my lords.
Can I just
In
say
this
something,
court.
Manoj? That point 3 at page 6, they say pushing a separatist agenda. Filing a 370 petition in this court is pushing a separatist
I'm
agenda.
sorry.
I have a very strong objection to the government of India taking this.
I'm
step here.
sorry.
All of us are pushing a separatist agenda by being.
Please.
One second.
No, I'll clarify.
One second.
Manoj, I
haven't-
Mr. Solicitor, please wait for a second. Mr. Shankarnaran, I think this is unfortunate. Nobody can say that because a petition under 32 has been filed, Up to this point, nobody has said that the filing of a petition constitutes separatist agenda.
I have said,
We have
Nobody is saying that.
why this date is mentioned,
One
even
second.
after filing, he has.
one second, access to our court for ventilating grievances of citizens within the framework of the Constitution is a constitutional right in itself. Anyone who accesses justice under Article 32 cannot be turned out on the ground that you are following this agenda or that agenda. On merits, which way any individual petition goes is for the court to separate the grain from the chaff.
May I clarify?
But I don't think,
clarify?
we have not, Mr.
The
Shankarnarayan,
intervener-
we have not heard the government.
Saying this about us.
We have not
Only
heard
a
either.
minute, Mr.
One second,
Shankararayan.
Mr. Solicitor, 1 second. We'll put a lid on this now. Otherwise, this will go on endlessly.
Only give my.
1 second. We have not heard either the Attorney General of India, who is leading arguments for the Union of India, the Solicitor General, who has shouldered a large part of the burden, say that these petitions should be dismissed on the ground that they are separatist agenda. They have argued the matter on merits. It has been argued on constitutional terms. We have indicated that that's how we are going to resolve this issue. And I don't think that's been the main plank of either the solicitor, the attorney, or anybody who else who followed.
That's all I'm.
Sometimes when individuals as interveners come before the court, we also as judges understand that
They are
there is
petitioners. They are the lead
an
petitioners.
anguish which was
Solicitor
expressed,
is not the intervener.
and that anguish which many of the interveners have expressed, we as judges know how to deal with that.
Give me a minute more. Give me a minute more. The date for 18th March is mentioned that petition is filed to show that even subsequent to the filing of the petition in May to 2018, etc., my lord, this continued.
Mr. Solicitor, you have
Filing of a petition
Mr.
is
Solicitor,
not as a.
You have made your point. You have made your point, Mr. Solicitor. Mr.
Yes.
Sibal.
Well, I hope that sentiment applies to us also because we have not made any submission other than on the law and the constitution. Just as the other side has done it, Mullah, at least we have not made any submission outside of that, Mullah. And we want to carry on this debate, Mullah, through the constitution, not through processes of this nature. Anyway, Mullah. Now, Mullah, yesterday your lordships asked me a question about merger, how many mergers have taken place. Kindly come to volume 4.
One second.
Mullah, I leave it to the court, Mullah. I
Mr. Judge, please don't interrupt. There's a limit to it.
There is a boundary.
Yes.
Mullah, it's volume 4.
Just 1 second, Mr. Sibal.
That's another 20 minutes gone.
Mr. Sibal, is your client, has he filed an affidavit pursuant to what?
He is going to file, he is going to reach by 12 o'clock.
Yes, now on merits, Mr.
Yes.
Sibal.
So, Mullah, volume documents, volume 4, PDF 303.
Volume 4.
Yes, PDF 303, Mullah. This is in the white paper, Mullah.
303?
303, Mullah. Mullah, this has taken 20 minutes. Yesterday, half an hour. The lordships had given us from Monday, Mullah, onwards, morning, Mullah. How do we finish?
This is the white paper that is.
White paper. Now, let's kindly see appendix, statement showing area and population of states which have merged with the provinces.
I'm sorry, which page are you referring?
Page 303, PDF 303.
PDF 303 in volume number 3.
In volume number 4, document volume 4. It's very important, Mullah. So this is, as I told your lordships, all the states who joined the provinces. And then they were merged, provinces which merged. So they first joined the provinces and the provinces merged. And you have 21 such mergers. And the dates of the agreements are on the left side. 1148, 1148, 1248. This is after Mullah's January 20, before January 26, 1950. This is important. This didn't happen with, as far as J&K is concerned. Malas. Now, this is now one part. Now kindly come to the next table. That is statement showing area and population of states constituting central administered areas, which were the chief commissioners' provinces. Now you see here, there's no question of any merger. No question of any merger. It was directly administered. But through merger agreements.
Now these, just for a factual clarification, these centrally administered areas, what was their status under the Government of India Act? Were they were treated as chief commissioners' provinces, and they become centrally administered areas
Yeah,
after.
correct. Now come to the third. These were princely states, Malas, which actually went to the unions. These are princely states, Malas, many of them. Kindly see, Malas. Manipur, Tripura, Bilaspur, Kutch, Haroch, Chamba, Mandi. These are all Raja of Mandi. These are all princely states that merged into the chief commissioners' provinces, which are termed as chief commissioners, directly administered.
Then the third statement is those which constituted unions.
That's right.
So
Now
they
these,
formed a union of more than one of the.
correct. Now this is important, Mullahs. Kindly see how the merger agreements here, only 5. Now you'll see, Mullahs, item 1, 22 units, as I told your lordships yesterday, in Saurashtra. Then, Mullahs, Jodhpur, Jaipur. This was called originally Rajputana, which included all these. Then you have 15648, Madhya Bharat. Your lordship sees that? Madhya Bharat. Then 2848 Patiala, East Punjab, Union, and then Travancore, Cochin. This is 552. Total 275, grand total 552. So you have therefore the chief commissioners' provinces. You had the province, princes merging into the provinces, and you had these 5 states. All through merger agreements. No exception, except Jammu Kashmir. Because that was not conceived in terms of 370 itself. Now kindly come to 373, Madas. This is also important. PDF 373. 3. Now what in these 5 provinces called the Union of States, what were the kind of notifications issued, Malas? What were the kind of proclamations issued? Your lordships will find at 373 onwards.
So this 552 was an addition of 216 plus 61 plus 275.
Correct.
Yes.
Correct, Malas. So now if your lordship comes to PDF 373. Now, you see that Raj Pramukh of Union of Patiala, East Punjab states, Saurashtra, Travancore, Rajasthan, Madhya Bharat, rulers of Hyderabad, Mysore, Jammu Kashmir are published. This is the proclamation. What does the proclamation say? Last paragraph, I now hereby declare. Your lordship has that? My lords have that? It says, I hereby declare that the Constitution of India shortly to be adopted by the Constituent Assembly shall be the Constitution for Patiala, East Punjab, as well as other parts of India, and shall be enforced as such. Come to the next one, Malas. Each of them, Malas, had the same proclamation. Each of them. And all that happened prior to 1950. Except Jammu and Kashmir. And you'll find that at 379, Malas.
Sibal,
And see if you...
Mr. Sibal, do you think it would have been a unilateral action or it was?
Sorry, I can't hear
action-
you.
It was an action on its own, or it was something which was the government of India at that time ensured that it happened. Obviously, the government of India, government of India ensured that it
There
happened.
was no question on its own, Malas. It would never happen like that. Some of them couldn't exist
So
independently.
we have understood your argument on that. Can we move on?
Now, let's look at PDF 379, because all those proclamations are different from the proclamation Kwe Jammu Kashmir, which is Malas 25th November 1950, before Malas the 26th January 1949.
The proclamations is the firman of the Nizam as well. The Nizam you find at page 377,
Yeah, but the
23rd of November
but the language is
1949.
different.
This was certainly not voluntary.
Of course not. Of course not, Malas. I agree. This is what I responded to my lord. But Malas, the language is different from Jammu and Kashmir.
So keeping you probably in J&K, keeping at that time the political environment, it was something different. Was something different.
That's all that I'm saying, Malas.
That's
My
the argument
argument-
you have, we have understood that
Yes,
argument.
and therefore it was incorporated in these terms in the Constitution, which was not done by anybody else. Which only shows to you that merger was never contemplated except in terms of 370. All the others became Malas through these proclamations, part of these states, and then became part of B states. Malas. All these states became part of B states. Jammu Kashmir Malas were not. It was the only state excluded from Part B states.
But equally, the proclamation which Yuvraj executed, which you find at page 379,
Yes.
which we have seen earlier,
Yeah.
says that the entire relationship between Jammu and Kashmir and the Union of India will now be governed by the Constitution of India.
Correct.
And all previous understandings
Are gone.
are all superseded.
Absolutely. And see what the language is. The Constitution of India shortly to be adopted shall be insofar as it applicable to the state of Jammu and Kashmir, govern the constitutional relationship. So you go back to that. That is 1 and 370 only, Malas. Nothing more than that. I just wanted to show your lordships, Malas, because your lordships put me this question. I think it was a very significant, Malas, query. And they all followed a uniform pattern of integration, other than Jammu Kashmir. And Malas, the white paper also says that the integration of states did not follow a uniform pattern in all cases. You will find that, Malas, at page PDF 46.
Because you have to deal with them differently, all the.
Naturally.
I have understood that argument. Today, the issue is not this. Today, the issue is whether 370 was really a temporary thing and whether
No, but
in terms of 370, it could have.
I'm giving the historical background to show the difference and why he did not merge, because in the meantime, many things had happened, including the matter going to the UN. This all happened prior to this, Malas. Therefore, the question of merger didn't arise. That's the point, Malas.
Sibal, that has all been argued in your opening arguments.
No, I'm only giving the background to 370, Malas. I'm not arguing it. My lord put it to me. I'm just giving the background, nothing more. I'm not arguing. I've argued 370, Malas. I'm not arguing, Malas.
Historical background also you have given in your opening argument.
No, not the merger, because my lord put me the merger agreements. There's a difference between merger agreements in all other states at that time, that is the 552 states, and except for Jammu and Kashmir. That's all, brother. And they have argued merger. I did not argue it. Anyway, be that as it may, Malaj. Malaj, if just one other thing, Malaj. Since we are at this, Malaj, your lordships put to me yesterday, and then I'll come back to Malaj, the 355. Your lordships put to me that, look, there is a silence here in the Constitution. Malaj, I just want to answer that. You know, I'll Malaj, read what I have to say on this, Malaj, so that it's on the record. My first statement is integration was completed when the Constituent Assembly of Jammu and Kashmir completed its task and the Constitution of Jammu and Kashmir was adopted on 26th of January 1957. The governing structure comprising the Constitution of India and the Constitution of Jammu Kashmir complement each other, and through the bridge of Article 370. The scheme operated without conflict for 70 years. This very scheme. There was never a conflict. Two, through this complementary structure, the vast majority of provisions of the Constitution of India are applicable to Jammu and Kashmir in one way or the other. This was the integration meant. Nothing further needs to be integrated. Indian constitutionalism is not bound by a single scheme of legislative relations or any homogeneous understanding of the concept of integration. 3. Article 370, sub-article 3 is not silent. What is my answer to that? It is not silent as to the consequences reflecting the relationship between Jammu and Kashmir and India after the Constitution of Jammu and Kashmir was framed and the Constituent Assembly completed its constitutional task. This is further buttressed by the fact that in 1954, by CO 48, a proviso was added to 368-2. That can't mean that the 370 was silent on the consequences. If it was silent, 368-2 proviso would never have been added. Ensure that Article 370 could not be amended, even through the exercise of constituent power, and that by virtue of CO 48, the boundaries of the state of Jammu Kashmir could also not be altered, as long as 370 was in place. The Article 368 does not apply to 370 is clear from the fact that 370 starts with a non-obstante clause. So it was not silent as to the consequences. Next, there were no silences left to fill except the silence of the people of Jammu and Kashmir, who were never consulted and taken into confidence when issuing CO 272 and 273. That's the only silence that prevailed. Bilateralism is at the heart of the mechanism provided by Article 370, in terms of which laws applicable in the Union of India through the Constitution of India as applicable to Jammu and Kashmir are to be applied. It is this bilateral process which allows for a process of integration that is constitutionally envisaged in Article 370 of the Constitution, and any adjustment of the relations between Jammu and Kashmir and the Union must follow this bilateral process. And last of all, even with respect to 368 of the Constitution, the process of exercise of constituent power resulting in amendment of the Constitution is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least get agreement of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Malas, what we're talking about, a unilateral act of the president acting on the aid and advice of Council of Ministers, not Parliament. So, Malas, with respect, I say there is no silence. So that was, Malas, just our submission, Malas, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Malas. Kindly, Malas, just look at this. Yes. Now, if you see, Malas, I'm not going to read the language. Just want to ask your lordships to notice three things. One, there are entire Article 370 has 2 colons. The rest are all semicolons. And the 2 columns reside where, Malas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub article 3.
colon after D,
D, matlab 37 1D and colon after